right, well, I'm going to say welcome to everybody who's gathering in the meeting room, wherever that happens to be. My name is Jim Pamplin. My business partner is Viju Katungal, and our mentoring partner is Dave Dinkle, and we want to thank you for attending tonight. We appreciate you. The fine folks you see are our speakers and our business guests. You'll hear from them in just a moment. DREIA has been in business since 1996, and our motto is we practice what we teach. And you'll hear a lot of that tonight. So we hope if you want to learn more, you'll visit DREIA.com. So Vijay, I'm going to turn it over for a welcome and introduce our business guests.
Welcome, everybody. Thanks for joining us on a rainy evening. I'm going to go ahead and start introducing the business members. Jim, you want to go ahead first?
Sure. I'm Jim Santiago from Independent Title. I'm a title agent here in Florida, handling investor-oriented transactions, keeping prices low, efficiency high. Somebody's answering their phones every hour during the business hour, answering emails as much as we can, getting your deals closed as efficiently, cheaply as possible. So I'm Jim Santiago from Independent Title, where you get that Santiago satisfaction. If you scan my QR code, you can text me.
Oh, sorry. Becky.
Hi, everyone. I'm doing well. Glad to be here. My name is Becky. I'm with Real Estate IQ, and we have leads, off-market leads. We have the pre-foreclosure, lis pendens, probate, code violations, delinquent taxes, and a couple others. So we also have a great thing for you because you're here. You can try our leads for a month for free. And so I'll put that code in the chat, hopefully if I can figure out how to do it on my phone. But we also have the option for you to get those leads with the skip tracing information already attached when you get them. So give us a try. If you sign up for the trial and then let me know, I'll give you a trial of the premium as well. So thanks for having me here, guys.
Thank you. Thank you, Becky.
Thank you, Becky. Ryan, you want to go ahead and give us free, or are you going to do that during your...
Oh, I'll save it. I'll
save it? Okay, perfect. Erica.
Hi,
Erica.
how are you? I'm here.
Good.
Hi, my name is Erica with Creative Title Services. I have been doing title for the last 29 years. We specialize in investor closings. We're 100% investor friendly. We're available 24/7. You can reach anybody in our office. We're going to call back within the hour. My number is 305-476-8733. Thank you.
Thank you. Michael.
Sure. I'm Michael Clavin. I'm the owner of Adjuster Man Public Adjusters. Disasters obviously happen all the time, but that has definitely not been my experience with DREIA over the years. What a great group. Yeah, we settle large loss insurance claims. When it's broken, burnt, or bashed, flooded, smashed, or crashed, you need Adjuster Man Public Adjusters to be able to tell your insurance company what the true scope and full value of your insurance claim is, so that you get paid everything that you're really owed by your insurance carriers. Recent changes to the insurance laws, SB 76, have made this even more difficult. At this point, you really need a public adjuster or an attorney to do just about anything when you're dealing with your insurance carrier. Please, if you have damage from fire, theft, vandalism, escape of water, tornadoes, or hurricane season starts in 2 weeks, call us here at Adjuster Man Public Adjusters. When it's busted, we'll adjust it.
You can find all of our business members at DREIA.com under business members or vendors.
Hi guys, these are so few other properties we have. I mean, everything that comes to us have been selling pretty fast. So if you're interested, give us a call or send us an email. That's it. Thank you. Jim.
All right, yes. You visit our website, fixersforrehab.com, or call us at 305-758-3133.
Or go to DREIA.com and it's on the top of the screen. to click on.
So now, Viju, we're ready for Gus, I think.
Yes, hold on 1 second.
Oh, is that a good looking guy?
Yeah, there we go.
I don't know.
I was talking about you, Viju. Okay.
All right. Gus has been helping real investors for decades, I think, feels like, right, Gus?
23
So-
years practicing law and 22 of those representing investors. I don't know if anyone out there is old enough to remember, but well, I guess DREIA was around there. We had a little investor club called ARC, Advanced Real Estate Investment Club. It was not as big as DREIA, but that was like 20 years ago. And that was like my first introduction to investors, and I kind of where I got my feet wet. I remember DREIA, didn't you guys used to meet back in the downtown area, right?
Yeah, we did at the
Yeah.
Omni.
At the
At the
Omni.
Omni.
Okay.
Yeah.
No, we're dating ourselves.
Yeah, really.
So Gus don't need no introduction. I'm going to go straight to Jim and Gus for,
So Gus, we already kind of covered, hey, Vijay, you can remove the sheet for me. Your investor business has kind of remained steady, right?
I mean, yeah, it waivers. I mean, last year, in honesty, was the best year I've had since I've been practicing law, and
Yeah.
it was just a bang buster year. And maybe it's because everyone had such low expectations when it started off, and with the pandemic at the beginning of it. But it ended really strong, and I was really happy how it ended. This year started strong, and we're still going strong, but it's definitely tapered off a little bit. I feel it at least, but
Well, since I've known you, which is a long time, it's always been surrounding investor deals, period,
Yeah.
and short sales. I will say that. So what would you say is a silly mistake that new and veteran investors can make?
I mean, the dumbest and the silliest mistake when you hear it, you're like, oh my God, I can't even believe I did that. And what I see, and it happens not often, but it happens frequently, believe it or not. And that's where you're flipping a deal or you're signing a deal and your dates don't match. You have an inspection period or you have a closing date that's farther out than on your AB contract and on your BC contract. So you're in a situation where you gotta close on a property that you're not going to sell until 5 days later or 10 days later. And if you were counting on, that sale happening simultaneous, you're in a tough spot right there because you just lost your buyer and you got to figure that out, go back to square one. So, I mean, it's not something that happens often, but it's something that is easily avoided. I mean, it's so simple to just avoid that by just paying attention to what you're doing and making sure that you don't, make that silly mistake. Another thing which is very similar to the closing date is the inspection, and that's also happens often where you might have a 10-day inspection on your original contract or 15, and you get someone to look at it and you give them an inspection date, which, I mean, if you're wholesaling a deal, you shouldn't be giving any inspection date, but nonetheless, that happens less frequent, but it does happen. So those are two little instances where they're easily avoided by just paying attention to what you're doing.
Well, what about Gus in the case where, let's say you're all set up with your A, B, and BC. B is the investor and the A is the original seller, but something happens and the A decides the AB doesn't close and you're left there standing. Has it happened where people just don't put a provision in their BC contract?
Yeah, well, my clients would never do that because they always know to put in that you don't own the property, you only own an equitable interest in the property, and that is subject to the successful closing of that property. So if you don't have that language in your contract, you're I mean, perhaps committing fraud. I'm not 100% clear on that right now, but I would say you're in murky waters because you're selling a property you don't truly own without disclosing that your interest is solely equitable and not that you don't own it outright. So you might be
So the C buyer has a remedy for that, right?
well, they have a remedy. Of course, they can always sue you, But in that situation, you don't exclude the remedy of specific performance. So that's not something that's available if you don't own the property. So I imagine the damages would be would multiply and be dramatic.
Yeah, right. So, well, let's talk a minute about contracts. You know, most of us, we certainly ascribe to using no special contracts. We like the FAR bar, the locally accepted contract between the Florida Bar Association and the Association of Realtors. But one things I've seen a lot of new investors get confused on is they say, oh, well, the contract insists that the seller take care of all the violations or take care of all of the liens, and they don't address it. They don't address, you know, specifically code violation. Now, a lot of people can construe that the contract says the seller will take care of the liens,
Right.
and maybe all that can be negotiated. But what about code violations specifically?
Yeah, well, code violations are not a lien, and they're not they don't prevent marketable title because it's not a lien of record. You could still transfer title and it'll be acceptable. And I think 9 out of 10 attorneys would agree that that is marketable title. Obviously, there's always room for debate, and you know that's what keeps us lawyers you know, employed is the gray area. But overall, I think most people would agree if you don't specify that code violations or open permits are going to be closed prior to closing, that's open to debate. And you don't really want to be in a situation where you're litigating or debating these issues when you're trying to close and get paid. So, I mean, obviously, the more specific you are, the better. I always tell my clients, pretend you're making a genie wish. When you tell your genie what you want, you better be as specific as possible. You don't say, I want a Ferrari. I want a red Ferrari, you know, with low miles and in this color and this year. So be specific, be clear, and make sure you include everything. I mean, touching on something that I want to go back to something, and that's like closing costs. And that's another area where a lot of people, there's some area for debate as to what is closing costs. If you say buyer, seller agree that buyer will pay off seller's closing costs. Well, what is seller's closing costs? Does that include doc stamps? Does that include proration of taxes? Does that include all these other fees that can be considered closing costs? So if the deal is that the seller's netting 100,000 and you put $100,000, but and then you put all closing costs to be paid by buyer, and you don't specify that the doc stamps are being paid by the buyer. I mean, I think that leaves some room for debate as to whether that's included or not. So you want to be as specific as possible. You want to address these areas, and you want your contract to be. You want to match up your A and B contract, and you want to make sure that both sides of the contract are the same. So you have a situation where your A contract says buyers paying closing costs, and then your B contract has sellers paying closing costs. So you have a problem there because you're paying closing costs twice. Paying on the A and on the B side. So you want to make sure that you get these things and you try to pinpoint what you're trying to accomplish.
I mean, I think that's right. I mean, you know, there are certainly times where it's advantageous to do that, but you need to know you're doing it.
Right.
And I think that FAR bar paragraph 9 pretty much breaks down what is expected, what a buyer closing cost is and what a seller closing cost is. But when you're dealing with someone who hasn't sold a house in 20 years, they may think taxes are a closing cost. They may think doc stamps are a closing cost. And so I've seen this happen a lot. Have you seen closings like not take place over this stuff?
Yeah, I've seen them go down to the wire over situations like that. And specifically, I think past due taxes is something that like is kind of in a gray area and it isn't addressed really in paragraph 9, like you mentioned. But it's something obviously that most people would say that's a seller expense. Obviously, you need to remove the lien on the property and pay the taxes. And I've been in situations where, you know, you got an old guy that's saying, hey, I'm not paying that and I'm not closing. And it becomes a little bit of a push and shove match trying to figure that out. So yes,
So your analogy is perfect. If you're going to say pay closing costs, you really should define to the person who's not as familiar with it, what is closing costs, just to be fair to everyone and make your transaction go smoothly.
Yeah. and make it, you want to be in a situation where, you know, the letters on your side, the contract is on your side, and you could point to it and say, hey, look, it specifically says here, especially if you write in additional terms, the buyer is paying XYZ, not paying, you know, this fee or that fee. Buyer will pay, you know, title search and lien search, but sellers to pay for prorations and past due taxes and any open permits or anything of the sort.
Yeah. So Gus, in our business, you know, we're firm believers in using two contracts, a buying contract and a closing contract, because, you know, Dave tells us, you know, we don't do business for peanuts. But sometimes it is okay to use an assignment of contract when a profit is not going to kind of make anybody on either side upset. Now, tell us about an assignment contract. Just tell the people what is the advantage of using an assignment contract and how it mechanically works.
I mean, the main advantage of using assignment contracts is reducing your fees as the wholesaler, I guess, the man in the middle, the investor that's you know, facilitating the end buyer getting the property, however you want to classify it. So so it works, especially when you have deals with thin margins, or when you have deals that have sophisticated end buyers, or the sellers are not very concerned with what profits are being made or who's making it. They're just concerned about getting X and they want to get out of Dodge. And in those situations, an assignment works well. I mean, what I've seen in the problems recently, the problems that I've seen with assignment is, like, I have a few clients that use them more than they should. And the situation they have is they use a blank assignment. And typically, for those who don't know, I'm not sure like how well informed our audience is here, but an assignment is where, like, let's say I'm buying a property from Jim, and now I'm going to I get it under contract for 100,000, and then I'm going to resell it to Viju for 120, let's say. In that situation, I could assign my rights in Jim's contract to Viju, and Viju would either pay me an assignment fee at closing or at the time of assigning the contract, whatever you guys, typically it works at closing, but sometimes people do it at the assignment of contract time. I mean, very infrequent, but it does happen. And I would be receiving $20,000 in that instance, and Jim would be receiving his 100, and Viju would be paying 120. And typically, the way that works is an assignment of contract document is prepared, and that document basically says that Viju is assuming my role and taking over the contract with Jim. And the issue we've seen, or the problem I've noticed lately, is that I have some clients that are really pushing that to the limit and getting some really good assignments. And the end buyer's lender is the one having the problem, because at the time of closing, Viju is purchasing the property from Jim for $100,000, not for $120,000. The 20,000 is coming to me, and the purchase price is still 100,000, and the doc stamps will be 100,000, and it'll be recorded in the public records at 100,000. So if Viju is planning on getting that property and fixing it and reselling it, that's going to give him a problem with his comps when he goes to relist it or resell it, because they showed that he only paid 100 when in reality he paid 120, and now he put 20 into it and he wants to sell it at 180. They're going to say, hey, well, you know, where are you getting this value? And I'm just using very simple numbers just to make it a simple example. But in reality, you with these assignments, you have issues with your lender, and then and your resale with the value, because you're paying Jim's what I was paying for Jim. So that's something that you got to keep in mind when you're doing assignments.
So the base contract is what gets recorded. So the base contract before
Right.
the assignment, that's the amount that gets recorded.
That's
Now,
that's recorded.
Does Viju get to see that underlying contract?
Well, and that's the way it's typically done is no, it's not. We black out all the purchase price. He gets the contract, but he doesn't see any of the purchase price information until the day of closing. All he knows is he's buying it for 120. He doesn't know if I bought it from Jim for 100, for 50, or for 119. He doesn't have any idea what my purchase price is. So that's a Sunday surprise that they usually get the day of closing. And when they have a lender involved, and the lender sees a closing statement where the purchase price is 100, and maybe they're getting a loan for 100, so that you have a lender that's a little hesitant to lend when they see that the purchase price is less than the loan amount. Maybe if we change that example a little bit, let's say I got a great deal, Jim really was asleep that day, and I got the property for 100 and I sell it to VG for 150, and the spread is nice and thick, the lenders are going to have a tough time, because VG goes to my, hey, Mr. Lender, I'm buying at 150, and then he gets a closing statement that says the purchase price is 100. So that's just something I've seen with some lender. There's a lot of lenders that are okay with it, but that's just something that I just think a lot of new investors especially should be careful with, and make sure that your lender is not going to have a problem if you have a real big assignment fee, because I've seen that be an issue recently on a few transactions.
Okay.
And
So,
another thing with assignment, which is a magic, no one knows the secret formula, but I've had sellers that see an assignment fee of $5,000 and freak out, and I've seen sellers that see an assignment fee of $100,000 and not even think, bat an eye, can care less. There's no magic number that is where people are going to see and feel like, oh, this deal is unfair. If there was a number, I'd be telling everyone, I'm sorry, it doesn't exist. It's just, you never know. And you never know who's going to be the seller that gets upset. So, I mean, I try to tell my clients, try as much as you possibly can to do double closings, because in the end of the day, it's the safest way, where your buyer and seller kind of keep away from each other, and you stay in the middle, but they never touch hands. But I mean, if it has to be an assignment, those are pitfalls you want to try to avoid.
well, our philosophy is, if it's a good profit, pay the $2, pay the $2 and close both sides, and there's no risk.
Right.
I mean, that's, and Dave and I have been, and Viju and I have been through a number of experiences. Oh, it's fine. It's fine. The seller is cool.
Yeah.
The seller then just goes ape at the closing. And so you don't do that.
Yeah, you never know. You never think you could gauge it. Like I've had clients that say, oh no, the buyer's fine with it, and they're making a $20,000 assignment fee, and the guy's fine with it. And then you have another client that, oh, he's great, and it's a $5,000 assignment fee, and the guy's flipping out. So there's no magic number, and you never know what either party's going to think. So I always agree. I agree with you. If you can double close it, double close it.
And I think each investor needs to develop as a business plan a threshold that they will try, and above that they won't. And I think you can agree with your business partners or your mentors what that is.
Yeah.
And that's how we approach our business. We say likely, over X, let's don't do that. And we just don't. We don't take the risk. It's not worth it, because we work with title people that we trust, and we just want everything to go smoothly. By the time we get to closing, we've had enough problems. We don't need problems at the table.
Yeah, I'm glad you said that at the end, because in reality, it's like usually we're the ones that are dealing with it, because like the investor in the middle, they're not the ones that are talking to the investor's lender saying, hey, there's a $150,000 purchase. Why is the purchase price only 75? And you got to walk them through it. But there is a lot of investors, and I think a lot of your partners that you guys work with actually are very familiar with this, and you just got to shop around and make sure that the lender you're working with, these are the deals you're going after, make sure that they're comfortable with this, and they're ready to rock and roll when you bring them a contract and it's an assignment, and then you're buying it for 120, and it's really a $75,000 purchase that you're going to close on.
Okay, so I have a question here I'd like to pass to you. Relative to the question of code violations and or unpermitted improvement, is the rule of thumb to negotiate a lower price or walk away if the seller is not willing to remedy?
No, I mean, always negotiate and try to resolve the situation. Either get a buyer that's comfortable. I mean, if you're wholesaling it or if you're fixing it yourself, if you know what you're doing and there's a code violation, that's where you make money as an investor, because that's something that the seller usually doesn't want to deal with. And I mean, I've seen some crazy numbers like, especially when you get these violations that are accruing daily, a daily violation number, whatever, and you got $100,000 code violation where most times if you fix the problem and pay the city $5,000, it'll be resolved depending on the city and what the underlying issue is. But yeah, I think that's a good money maker for investors is obviously play it up to the seller and then, you know, take the problem on and fix it if you
But
can.
address it at the contract stage is the point.
Oh, yes.
Not at the closing stage.
Or why? Before, the soonest you can. You can't do that at closing. You need to address that as soon as you get a lien search back or figure out there's a violation of some sort.
Yeah. Well, one of the other things, speaking of violations, you know, we have novice investors who will agree to take on, oh, I'll pay the violations and I'll pay the liens. I mean, you know, that's just fraught with peril if you don't get some sort of search.
Right. Yeah. You need to know what you're getting into, and depending on the city, you have some cities that fixing like an open fence permit could take you 3 years and $20 million because it's just so complicated. And there's some cities that are easy to work with. So you got to really have a good grasp of what city you're working in and you know, get to know your code enforcement officers. Like if you're going to work an area, learn the code enforcement officers and what they want and how they want to fix these problems. Like I used to have a client that bought a lot of properties in the county, an unincorporated date, and like we had that down to a science. Like we knew, like as it was old, like a lot of like Hurricane Andrew permits, like old roof permits, like those were a dime a dozen out in West Dade, and it's a pain in the butt. There's an art to fixing those, and if you really learn how to maneuver through the code department, that's more of a profit center than learning how to, you know, market your business or sending out postcards or however you get your deals. If you learn how to get rid of code violations where other people can't, that's a good way of making a deal that most people will walk away from, a deal that you can take on and make some money on. So,
You know, Dave, I didn't tell you this. Several students were chasing an REO in North Miami Beach. And we went back and forth with the lender several times. The lady we represented the lender was very nice. She says, oh, don't worry about that. All those violations will be gone. I said, do you know how many there are? She says, no. So in the end, she did come back to me and said there were $2,100,000 worth of fees and said the city of North Miami Beach has agreed to settle for $2,788 and that the seller, the lender, will pay that. I said, well, gee, they certainly treat you out of town people better than they do us locals. Gee, $2,700.
Yeah, non-safety issues of some kind.
Yeah, they were just all just, you know, like, well,
Junk.
they were just those kind of issues. You're right.
Yeah.
Yeah,
Gus,
I just saw a question from Regina, which is an old friend and old client of mine, which I'm not surprised she's writing me a chat. She could just text me or email me, but I think it's a good question. And yes, you can cross out, because the contract you're giving is in an assignment is an example. It's basically just the terms. You don't need to let them know what your purchase price is. At least I never have, and I've never had an issue doing that. We just black that out, and because the price they're paying is the price on the assignment.
okay. We do it a little differently. A lot of times we actually say that Viju is going to buy the house for 100 and pay me 20. So it's just a different approach. It's a different agreement, so that everybody knows what's going on. And Taru, I would say if you want to look at what different cities to avoid violations, you just got to kind of network around and find that out. Okay, Gus.
I think that the smaller cities, especially like that have like 2 or 3 code violation code officers, are probably, you'll have more luck becoming a regular there than like a city of Miami or a city where there's like 50 code enforcement officers, and you'll never deal with the same person twice. You develop, you know, reputations, and you rapport with the code enforcement officers, and you kind of get to know them and what they want. Like some people care a lot about this, others don't care about that. You know, if I know like some code officers care if there's flower beds in the front of the house and if the lawn is cut. Others care if the roof is neat and the house is painted. Like it just depends. So, but
And
definitely.
you're right. You got to learn that by experience. And don't be afraid to talk to a code inspector at all. Their phone numbers are public.
Yeah.
And they'll either talk to you, they want. If they talk to you, you're in, you're in.
Yeah, I've never had any code officer like refuse to talk to you.
Yeah.
I
And
mean,
all they're there to do is do their job. So if you're helping them to do their job by fixing a property, that's what they want. So just be nice to them and help them, you know, not get in your face. That's the big bottom line.
All right, Gus, any last minute tips for new investors or veterans?
another thing that I wanted to touch on that I didn't think I went over, and that's like another issue that I've seen a lot of investors recently like have mess up with is like dealing with tenants and post occupancy agreements and like property conditions at the time of closing. A lot of these sellers that you're that you're getting a deal from and they just want out, they're not typically the kind of people that are gonna pick up all their garbage and like leave the house nice and shiny. And your buyer, depending who he is, might not want it in that condition. So my clients I have a lot of investors that are very specific, back to my genie wishes. And like they put on their contract with their, like the properties as is, you're taking it like if there's an old refrigerator full of garbage in the kitchen and there's, trash thrown all over the floor, that's the way you're taking it. Or the opposite, we want the property nice and clean that you could eat off the floor. I just think the property conditions and the occupancy, some people, like, especially now with the moratorium of evictions and stuff like that, no one wants to take on tenants that are going to be a problem. So, and especially in a lot of these properties in like the area a lot of investors work in, you have a lot of holdover people, and you got to deal with that beforehand before it becomes a problem. So just be very clear on both your contracts. If going back to the ABC contract, if that's something you want, an issue you want to avoid at closing is making sure that the tenant, when they're leaving, if there's a post occupancy agreement, who's putting up the money, who's getting it back, how many days, all those issues are ironed out before you get to closing. Because if anything I've seen recently that causes turmoil, that's it.
That's it.
Just some final words.
It's just a fact in our deals. Gus, thank you very, very much. Gus, do me a favor. If you want to type anything in the chat, please do so.
Okay.
Let me just see. Viju, are you okay with the answer we gave to Regina? Yeah. Okay. So Dave, Dave and I have worked with Ryan and Viju for a long time. So Dave, I'd like for you to make an introduction to Ryan and you guys take it away.
Ryan has been my go-to guy for a number of years now, not only for closings, because I've mostly been Broward and North, but also for legal matters. He's been by my side in mediations and a lot of things we've been through together. And we've had some, honestly, Perry Mason moments in front of other attorneys where we've been in litigation with them. And Ryan has come up with, well, what about this? And it was like, it was the end of the mediation. They literally walked out on us and made us an offer, which we couldn't refuse. So if you think you have to have mediation or you don't think you have to, I trust Ryan immensely for all he's done. I probably have 4 or 5 litigations going right now, and I'm not a litigious person, but there will come a time when you have to enforce a contract or something, and it's best to talk to somebody that does it on a regular basis. And Ryan has been spectacular in what we've done. I don't know if you're going to talk about partitioning of estates and things like that at all if we have time, but I'm in one of those, and we just had one where the one unruly brother who said, I'm not signing anything, I want more money than my 2 sisters. We went to the foreclosure sale on Tuesday, had been stopped a couple of times. And the last time we got an extension on it, the judge said, yeah, I'm not going to give you another extension. So on Friday, we had a face down, and I said to the student that I have as a partner in it, tell them no, they're not going to get anything. We offered each one of them $3,000 for the entire property. And he wanted $5,000. And if you're saying to yourself, gosh, that's really stupid, for $2,000, you didn't get the property. There comes a time when you kind of learn what people are all about or not all about. And I took the guess that this guy we weren't gonna back down, and he was. And it turns out that that's exactly what happened. So we have that property now, and what will we make on it? I don't know, but fairly substantial amount of money. So look, I'm the guy who has always been there on the front line of trying to tell people how to do things without practicing law. But I can say to you that I know that when it comes down to actually putting these things in motion, it's better to have an attorney behind you to put them in motion than doing it yourself. And I'm not taking away from Gus. I've worked with Gus for probably 15 or 18 years. Gus is a litigator when he has to be, but it's not his first choice, I don't think. Is that fair to say, Gus? Gus would rather be making money on deals than doing things like that. That's ideal. But in the situation, if you do 1 or 2 deals a month, you got a chance that that's going to happen most of the time. When you're doing, I closed 10 deals last Wednesday, and I can tell you that a lot of stuff comes up. And if you don't have somebody on your side, you can make decisions that you know are going to be good in the long run. You better do it yourself. Better do it with somebody else that's there with you. Now, look, here's the thing, and I try and stress this to people. Nobody wants to pay attorney's fees. Nobody wants to pay closing costs. Nobody wants to pay for anything. But in the real world, if you lose one deal or save one deal, you make a lot more money than being chinchy about doing things. It's like the assignment. On the internet, all I hear from these guys is sign your contracts. I'm doing 110 contracts. Everyone's an assignment. And oh, by the way, we had one that was $22,000 recently. Every other one of them is probably $3,000. Had they done a double closing and marketed the property rather than just to an assignment list of buyers, I have put in one of my videos that the ones that I've viewed, the closings that I've viewed, are somewhere between 5 and 25 times larger profits by doing a double closing, because you can, first of all, build a bigger buyers list and get more money out of them. But again, I'm not there to argue with people. You asked me, and I'm saying to you, if you had said to me 5 years ago, do you need an attorney almost on staff? I would have said to you, no. I've got myself through these things, gone to my own mediations, done that kind of stuff. But as we get more and more and deeper into issues, I'm going to say, you're best off to seek legal advice and not free legal advice. So enough said. All right, Jim. I over-introduced him.
All right, so I'll take over. The goal really is not to litigate, because, and even from my standpoint, the litigation is a lot harder of earned money. It's probably why Gus prefers not to do it. He's got a couple years on me. And so when I catch up to him, I'm probably not going to do it either. But the goal is to stay out of litigation. And to do that, and to get deals closed, there's some, I guess, big errors or the biggest mistakes I see that are made. And I was going to talk a little bit about that, and jump in or stop me if you want. The biggest issue for both newbies and seasoned investors is probably communication. But I'd like to break it down a little bit by topic, newbies and then seasoned investors, as to what I see and what issues come up the most. And starting with the newbies. So anyone out there who's thinking about getting into real estate, wholesaling, it's a great industry, but there's a couple things that if you do wrong will really prevent you from getting traction and will slow you down. And so for the newbies, I would say one of the biggest issues I think initially is they overthink the deal. You'll have a potential deal, and instead of getting it under contract, they'll want to work out every detail possible in advance to the point where it's just not feasible to pre-close a deal or to figure out everything before you actually execute a contract. And that slows down a lot of stuff. And that comes to the effect where they'll want every payoff. They want to know exactly who's going to clear this or that, and just, you know, want title back, everything before you even have a contract signed. So what I would say is you need to get the contract signed, come up with a deal, communicate with the seller, and sign a contract. And it's always best if you have that inspection period that you could, you know, then figure out some of these issues that you're worried about. But similar to what Gus talked about, bad contracts, that I see over and over again. And I would say for anyone who's starting out, they should use the FAR bar. The FAR bar is the best one for them to use because it's the most fail-safe for them. It's the most common in our area, so there's less suspicion raised by the other parties involved, and it really prevents a lot of things. I often will see new investors or new wholesalers go out and buy a packet from somewhere online, and they'll have these homemade contracts or these guru contracts, and they're horrible. And then they'll use conflicting terms like the word closing cost, which is a horrible word because you should just define what you're talking about. Because then we have issues. Oh, does this lien count? Does this running lien that we didn't know about, does the child support judgment count? Did the seller think they were netting 100,000, but the wholesaler didn't realize that there's all these things that attach to the property? So try not to use words like closing costs. Say what you'll pay for it. Use the actual FAR bar, which spells the stuff out. One of the biggest errors I see is you'll have owner of record. And that's a fiction. What is owner of record? And what people are referring to is they often write the seller in on the contract as owner of record, and they're referring to the property appraiser's website. I think that's what they're referring to, but that's not always accurate, especially in these situations where you've had people pass away and it's a probate. So actually write the seller's name that you know of, or if you're not sure, call somebody. Call Viju, Dave, Jim, call, Gus or I or one of the other title agents and ask them, say, hey, this I can't figure out. Who do you think should be the owner? And don't add additional words in your contract like clear title. We'll give clear title. Well, what is that? The FAR bar has all these paragraphs setting forth the standards of marketable title, and then you throw in this new word that's not defined, which is just going to cause trouble. So that's one of the big issues I see a lot. And the other one that particularly to newbies is communication. A lot of times you'll have them give unrealistic closing dates. Sometimes, like Gus mentioned, the closing dates will conflict with the actual BC contract. So you're required to close before your end buyer is required to close. And that's a huge problem. If you're going to overlap, it needs to be the other way. The end buyer needs to close before you're required to on your AB. So if they back out or something, you have some wiggle room. Another one I see a lot is false promises. You don't need to give false promises or make things up. My most successful wholesalers are pretty straightforward. Now they're coy, they're smart. They don't say my goal is to make all the money in the world, but they don't give them some crazy line about having the insurance inspector coming. That's where they need access to the house, and they have basically they're marketing their property, and 300 different customers have come, all claiming they're the insurance inspector. And what happens is when you don't have the experience to have the ironclad contract, and you have these mistakes, because you're going to, if you have good communication, you don't have issues most of the time. So you need good communication, and don't give false promises. All that leads to is unrealistic expectations and frustration. And in these closings, anyone who's done a lot of them will tell you there's always unpredicted things that come up. So you need that goodwill. to be able to get that extension or to work this out or that out. You'll save yourself so much money if you try not to mislead or just be not genuine. And so that's one of the big things. I know I might be limited on time, so I'm going to jump over to some of the seasoned investors. The biggest issue I see with the seasoned investors is their failure to scale. So these wholesalers, these seasoned investors, a lot of times they were very successful themselves, and then they try to scale and hire staff and come up with these processes with software that just aren't realistic. And they'll want to come up with, hey, Ryan, I need a one-page contract that covers every situation, but leaves locks the seller in, locks the buyer in, but gives me every out. And I want to hire someone who knows nothing about contracts to fill it out and to deliver me a closed deal. And that's just not realistic. I mean, it's not realistic. So what ends up happening is, they spend their time not properly investigating things. These seasoned investors will have staff that go out and they start looking at a property. Turns out with a couple questions, they could have realized that the person they're talking to is not the real owner. It's the relative that may be staying there but isn't entitled to sell it, or that there's a mortgage on it and it's upside down, and the mortgage statement's been sitting there on the dining room table when they went out there. So when you don't try to overscale yourself, bring people on board gradually, and people who are as good as you were when you were doing it. There's a couple fatal mistakes you'll see, and a lot of them have to do with the scaling. But we'll go back to one of my clients is notorious for this. They'll get a probate property, and they'll have an AB contract that needs court approval, and the probate attorney, because of lack of communication, goes out and gets a buyer specific court approval, and then they try to wholesale the deal. And we have to say, hey, the court authorized the sale to John Doe or your company, not this random last minute. Well, can't we just? No, we can't. We have to go in accordance with what you went out and got. So, those are those moving pieces where it just bogs them down. And then the following up on things. My most successful wholesalers, you tell them, I need this. I need the affidavit of heirs. I need this document. They'll go out and get it. They'll hire a courier to go pick it up. And then you have the seasoned investors that want to push it on the title company. And yeah, the title companies will do it, but it's different. It's different calling on the phone and trying to get a hold of a person than you going out there and actually taking over. A couple other big ones I see that are issues a lot. Failure to make the deposit. And so whether or not you're going to make a deposit when you're required to is a business decision. You have a lot of wholesalers that send out so many contracts, it's not feasible for them to make deposits on all of them. But you have to have some level of due diligence. If you have the home run deal, if you're going to have a $100,000 spread, you better make that deposit, because when something goes south, you're going to have trouble enforcing the contract. The first thing that happens when you have litigation is they start looking for your mistakes. Oh, you breached this and that. So I don't want to be unrealistic and say you need to go out and make your deposit on every one you do. You should do that if you want your contracts to be binding. But if you're not going to do that, you better have good communication and make sure the deal doesn't go south. Or if there's a big enough spread and you want to enforce that, you better make sure you made your deposit timely. Because at the end of the day, you could say what you want. I've had all the stories. I've double checked with the wholesalers before I filed suit. You made your deposit? Yeah, with the title company, yeah. And then when it comes time to subpoena documents, the other side subpoenas a document, I look at them and say, I told you they were going to do this. Another fatal flaw sometimes I see with the wholesalers that are experienced is they'll assign contracts, but their assignments don't give them the right, or in their assignments, they don't retain the right to be able to sue the initial seller for breach. So all of a sudden, the seller's going to back out, and because they've assigned this contract up front, it's on the buyer to enforce it. And the buyer's like, I just wanted to buy a property for X amount. You know, the buyer wasn't getting the crazy deal. So you have to make sure you have your documents are good. If you know, you might have to enforce it. Have one of the lawyers or have somebody experienced take a look at your assignments and make sure it covers everything. One of the easiest ways to get out of a wholesaler's having to buy from a wholesaler is if it's in an HOA or condo, no wholesalers have the end buyer sign the required HOA or condo disclosure. And the state law says you have up to 3 days from the time you got these documents and this disclosure to cancel the transaction. So if you came to me and you said, I want to get out of this, I'll say, oh, let me see the signed HOA or condominium disclosure, and they don't exist. And it's because the wholesalers, a lot of times experienced one, are trying to streamline these processes and hire people who don't know enough. Oh, this requires the condo disclosure or the documents or something like that. So these are the little tricks of the trade. Realistically, you're not acting as lawyers. You're business people. So it's hard to have ironclad everything. There's always going to be a way around something. So the best defense to that is great communication. Stay in contact with the sellers. You won't lose them to another wholesaler who comes in and does a black hat move on you if you stay in contact with them. And I see that's a huge deficiency with a lot of the seasoned wholesalers as well, is they scale and they don't stay in contact with the sellers, and the next thing you know, someone else comes in and offers them a little more money. And there are, we have the different mechanisms to try to prevent that. They record the notice of interest or this or that, but you really don't want to go through all that. And so those are some of the biggest things I've seen. And if there's anything off the top of your head, I'd be glad to.
Well, Ryan, I want to go back and reiterate one of the things you said about beginners, and that is don't overanalyze it. If you talk to Viju or Dave or me about a property, the first thing we're going to say is tie it up. And that's the reason you have inspection periods. You will not win in this business if you do not make offers and get them under contract. There's so many ways to get out of the contract. And the other thing that Dave talks about a lot, and you brought it up just now, we don't do condos and HOAs for the very reason you talked about. There's a lot of footwork to be done to do it properly and not get yourself in trouble and not find yourself in a contract that is void or voidable. I'm not a lawyer, I don't know what that means, but the bottom line is you can wind up losing your whole deal if you don't act right on a condo deal.
Absolutely. And at the same time, I've seen, because it's gotten a little tighter out there for wholesalers, so I've seen them expand their horizon or their product, and some of them buy in condos in HOAs, and sometimes they're gonna improve it a little bit, do some work, and then flip it. And you got to be on top of that. I have one client who's notorious. I say, well, who in your company is making sure that everything's being done right? Because you're getting running fines from the condo in the HOA because you don't put the trash can away. No one's been to the property, and these notices didn't even get sent to them or wherever they have it going to the virtual office. And what are you going to do when it comes time to go ahead and resell it? You're going to fight the condominium association, the HOA, when time is, of the essence. You've got hard money on the deal or something, you end up paying it. So, if you can, you want to stay out of those because it's more complex. But if you're going to be involved, if you are going to go into condos or HOAs, you need to be familiar with the setup. These people are watching, condominium associations, they know everything going on. So if you're going to go do something in there, you might as well be nice and go make friends, because otherwise they can make your life very difficult. You got approvals and all these other things. But that's some of the biggest things, I see is the failure to communicate. you have to communicate and stay in contact with everyone involved, whether it's the seller, whether it's the condominium association or the code officer. Communicating is what, separates the big winners and the big losers. And that even goes into getting credits during your inspection period. Those are the ones that get the biggest credits, the ones who build the rapport and they communicate.
Dave, you have any questions?
Are you asking me? Did you say
I'm
me?
asking you.
What are the sources of the deals that you're seeing? Can you tell?
Yeah, the sources, I see a lot of stuff through probates, a lot of stuff through code violations and tax auctions. I don't see as much short sales. I really don't, as we did years ago. And even foreclosures, I could be wrong because I'm just on my end, but I don't see a lot of wholesalers buying properties that are foreclosure or pre-foreclosures. I just don't. And that could be because really it's that unicorn. The person has to have equity in the property and sat on it to a point to where they got to foreclosure. And yeah, when you find those, they're big, but it's not as I just don't see a lot of them. So the code liens, the tax liens, the probates, that's where I see a lot of it. And I think we're going to see more of that because for a while we saw a lot of the mailers where somebody just wanted to get rid of the property and it's easy. And I think with this market, that changes it a lot. The people know, hey, I know I need to work on this property. I don't want to fix it. I don't want to put all this stuff into it. And they used to say, let me just wholesale it. Well, now everyone knows that it's a seller's market. So I think you're gonna, if you're wholesaling it, you have to assume you're going to be there's more complex issues of code violations, probates, tax liens, that type of stuff.
You guys have done, excuse me, because I've been involved in probates for a while, you guys have done very well. And you guys completed one in less than 30 days recently. When you talk about how long do they take, they can take a long time. It used to be you have to have a 90 days, I think, as creditors can come in and make claims and so on. But in fact, if it's a homesteaded property and don't have a big chain of beneficiaries, they can be done pretty quickly, correct?
A lot of times you can. Now you have a couple in Dade County, you have a couple judges that will still insist that you do the publishing of the creditor's time period, which puts you 90 days out. And it's either I think there might be two of the judges down there that require that. And so that that if you on that random assignment that's a possibility, but you can get them done pretty quick. I could tell you this, if I were not to practice law or do closings and I was going to wholesale, I would probably nearly exclusively work with probated properties or properties with code violations because you have the largest opportunity to make money. Probate, you got to remember, that means they inherited the property. It's a lot different than someone who bought it with their hard-earned money and put all their sweat equity into it and everything. It's something they've inherited, and there's a lot of times they have relatives involved, which most people, everyone's got someone in their family that it's a pain in the butt. And so you're really, a means to an end. They don't want to have to go kick out the lazy sibling who's been living there and not contributing to the taxes or anything. So you're really a solution to a lot of their family problems, and it's an answer to headaches. And there's huge spreads that can be.
Yeah, it's a convenience issue for the beneficiaries. They want cash and they want out.
Absolutely.
And ironically, they don't want to pay an agent to list the property in most cases. They don't want to pay a commission.
And you can't, because the who's going to go over there and argue with Benny or Jenny, random relative who's been living there rent free for 20 years. You go tell them they got to sign off as well because they're 1/8 heir or something. And that leads me into one other area. if you are out there and you come across a situation where you have one heir willing to sell or one person willing to sell, and you don't have the other person or all of the sellers willing to sell, you have a potential huge profit, in my opinion. A lot of times people will move past it because they go, I need 3 seller signatures. I only have 2, can't be done. Move past, right? In this situation, you have the opportunity to, 1, get the remaining person to agree, which may not happen, or 2, to maybe even buy the interest of the agreeable person. And of course, it's going to be not just their proportionate interest, because you got a fight on your hands. So you're going to say, I want, you know, if the property's worth 150 and you're buying a third interest, you're not going to buy for 50. You say, hey, I'm going to have to go fight here, kick out your other 2. I'll give you 10. I'll give you 15,000, and you move on. And then you can do a partition and force the sale. And at a minimum, you're going to get your 1/3 of whatever the property goes to auction for. On the upside, you could get the other person to agree, or at least another interest to agree. So, I mean, there's huge money to be made doing that. It takes a little bit of litigation, but I think almost every one of the partitions that I've done or we've done, they've come out way ahead of where they would be if they just picked up, you know, the property a little under market value, or, you know, and resold.
One of the interesting aspects of the partition is it's like a foreclosure sale, except the buyer assumes any liabilities when he buys the property. So the funds that come into the actual court registry are net funds to the beneficiaries, correct?
I didn't follow you on there. As far as the sale?
Yeah, on the sale, the partition sale, let's say there's a mortgage in there of $100,000. The buyer of that foreclosed sale, I'm going to call it foreclosure, although it's not, he gets the $100,000 as a liability. So he has to factor that into his actual cost. Oftentimes they don't do that.
Yeah, you do. So you would have to factor that in, but it's more rare that you find there to be mortgages on partitionable properties, because that means somebody should have been paying it the whole time. And so I guess you could find it initially where the situation goes south. If it happens too long, what ends up happening is the bank forecloses on it, you know,
Yeah.
because they can't agree, they foreclose on the property. And then you have a different investor buying wholesale, or I'm sorry, buying, you know, foreclosures. And that's a different, you know, ideology or a thought process. But what happens, the interesting thing on partitions is, you know, there's no fighting. So if someone does not agree to sell, when you start the lawsuit and you prevail and they sell, all your legal fees come out of the loser's interest. So I mean, anyone who has a half a brain, if the other side, the opposing person, goes to a lawyer, the lawyer tells them, well, you guys better work it out, because, you know, you can't win on not selling. You have to sell. If you two don't agree, you have a right to partition in almost every, you know, situation. And when he or she prevails, you're gonna have to pay all their lawyer costs, and it's gonna come right off your cut, your split. So it's just a huge opportunity to make it. And on a caveat of that, every once in a while you have a property where the heirs, you can't find them all. That's another great opportunity. So say you can only find a portion of them. Well, you know, the other ones, until you find them, if it were me, I'd be renting the property out and cash flowing it until I can hunt down the person. So, you know, maybe it takes you 2 years, 3 years, but in that interim, you're you know, offsetting your costs. And so there's a lot of opportunity there. There's a lot of opportunity in those type of situations. There's no realtor that can list a property without all the sellers agreeing, you know, so you're already limiting your competition there.
Yeah.
And you know, you're not there's no buyer who's going to go to a lender. So it's really, it's a great opportunity. So if you're coming across it and you're not sure what to do, call up one of these, you know, call up DREIA, call up someone who's got experience, say, hey, this is what I have. You know, what do you think?
So Ryan, I want to go back to a point you made. So this is interesting partition. It sounds like we need to have another meeting on this, but if a property is in foreclosure, and there's a looming court sale, a partition is not a fair idea.
Yeah, it can, but it would just be, it certainly could. It all depends on where the equities line up at that time. But it's essentially, if you beat them to the party, usually if you were the person who's trying to sell, you would cough up the dough and pay the bank so it doesn't get foreclosed on. And then when you partition, you're going to seek contribution, for your expenses. So that's why you don't see them in foreclosure as much. But you ultimately could see
Okay.
them.
I mean, I mentioned that because Gio's sitting on something, working on something for us right now. And so we're trying to get both heirs to, it's a student property. We're trying to get both heirs to agree, but there is a looming sale. So anyway, so Gio will handle that.
So theoretically, if somebody had the money, I mean, I don't know the equity situation, but
Nobody has money. That's the problem.
well, then there might be another opportunity there for a wholesaler who has some money to step in, and I'll actually talk to him about that, and we should, because if it's, I don't know, we'll have to look at the equity situation and the risk, but if you're a wholesaler with the money, you might want to come put the money up, have them deed you over their portion, and then when you as part of the partition, you seek contribution from the other heir, their proportionate amount.
Well, we're open to ideas, so we'll look forward to hearing that.
But most of them you see, you really see them a lot at the tax deed thing. Is what happens is cousin Johnny's been living there, grandma died, all the, everybody, and like every year we're footing money out for the property taxes for this bum. And so you see them end up showing up on the tax deed auction more often than not. And it's just the relatives, I'm tired of paying for the freeloader and nobody wants to take it upon them. So a lot of times, if you're going to have to cough up some cash or do something to stop a sale, it's usually a tax deed sale as opposed to a foreclosure. And there's huge opportunities there. I mean, I've seen smart, sophisticated sellers take far less than they're entitled to knowingly because they didn't want to deal with kicking out their sister.
Yeah. Give us just a brief insight into reverse mortgages, because I see them all the time. What's just something, what's the general principle here? They're all insured, so you really can't do a short sale unless the property is ready to be bulldozed. But is there any negotiation space in them?
Yeah, I mean, there is. I actually hate reverse mortgages. They're horrible. So, I mean, they're just very difficult to deal with. Now, they actually will do a short sale a little bit easier than some other banks, because a lot of times they are set up to look at what's owed to them and what the property's owed. So, basically somebody took out a reverse mortgage. They had X amount of equity, and they allow them, sometimes they give them money, or other times they're just paying they give them money up front, or other times they're giving them money monthly, and that's chipping away at the equity. And they'll get this until they pass away. They'll never have to, pay the mortgage payment, but everything that they would have paid accrues. And then when they pass away, all of a sudden the reverse mortgage lender calls that due, and it needs to be paid off. Now, if you're a relative of their, say the reverse mortgage was on your mother's house and you're living there with her, you can call them up and say, hey, look, the amount that accrued was $700,000 that's owed because she lived till she was 150 years old, but this thing's only worth 100,000, and they will short it, but and they're set up to do that, but they are a pain to work with. The payoffs, all that stuff takes forever. Sometimes they'll want you to do a probate just to get a payoff, and you can spin your wheels with them. So again, it's one of those things where there's very few, title companies right now in this market that are going to go work a reverse mortgage short sale for you, just because everyone's slammed with work. They'd be, I'd be lying to you if I told you in my office we'd make that priority number one. It just financially, it doesn't make sense when were slammed, and it's a, you know, crapshoot. You're not sure if they're going to go for it. So if the wholesaler wants to do it, yeah, they could call and spend the time and try it out. But I haven't been seeing a lot of those coming through, and haven't seen a lot of the short sales lately.
Yeah.
But not to say it won't.
Hey, Jim.
So, Brian, I have one question here from Bettina. Thank you, Bettina. What is Ryan's opinion of tired landlords as prospects?
Tired landlords. I think tired landlords are great if you want to buy some property and you want to hold the mortgage. I see that a lot, but I don't know that I've seen huge discounts because somebody just doesn't want to deal with it anymore. If you're a landlord and you've done halfway decent for any amount of time, you're usually not too unsophisticated. They know they could probably list the property and sell it. So if you wanted to start, building a portfolio and owning real estate yourself, tired landlords are excellent to have them hold a mortgage. You make payments to them, and you can ultimately acquire the property. But I don't know that if you're going to wholesale the deal, you're going to find a huge spread there. But I could be wrong. That's why I do my end, not the sales end.
I don't know, Ryan, you sound like you could be a very sophisticated investor. And in fact, I think if you're on for it, we may do like a daytime or a Saturday workshop on a couple of these items. Would you be willing if we can get a crowd?
Absolutely.
All right. Anything else, Dave?
No, I think we're pretty good.
All right. Well, Ryan, there's a couple of other things I want to talk about, but I'm going to postpone it, and I'm going to maybe get you to help me write an opinion piece, because I think people are really interested in this topic of what to do as an investor. And I think that for those who come into the mentor program, we kind of cover this ground. But I think it's good to hear it from an outside person. So I appreciate your time tonight. We appreciate you always participating in DREIA. Ryan is always there when we ask him, and we really appreciate that. So Dave, I'm going to move it on to you.
Thank you, Ryan.
I'm going to sign off.
All right.
Okay.
Good
Thank
night,
you,
guys.
Ryan.
Thanks. Good night,
Take
Ryan.
care.
Go see the kids.
I have a interesting commentary before we start on the rental thing that I did. One of our
Dave,
students.
let me know. Hold on. Dave, let me know when to start.
Okay. So one of our students from way back, 3 or 4 years ago, also is licensed, and he has worked for years with a friend and associate. And what they've done is he accumulated properties for the investor. The investor is a well-known doctor, and he just wanted rental properties. And what they focused on predominantly were single-family homes. And this goes back for the past 5 years or longer. And they bought what were good buys with good cap rates on them. And they accumulated a set, I think it's 15. Actually, Ryan closed all of these. But they decided to take them to an auction. This is one of the problems that landlords who build portfolios over time face when they go to get out. Instead of getting out like one at a time, they decide they want to move the whole portfolio. Typically, it's for financial planning purposes. Perhaps something is ending their life, like whatever, and they need to move them. So what they did, and I'm going to do an interview, hopefully in the next few days, if I get time, with that student, and he's going to talk about how they went to one of the foremost auction companies in the United States. Those properties were auctioned down here. They're all in South Florida. And how they put it together. They went ahead and auctioned those properties. And what happened is an investor came in and made an offer on the entire lot. And they accepted that one lot, even though they had all the closings separately. They decided rather than take the shot at doing them one at a time in the auction arena, take the auction. So the investor came in, bought those at what was, I'm going to say, appeared to be fair market value based on rental incomes. However, they're single family homes. And what that investor did is resold them literally as soon as he had them under contract and made almost as much money, 2/3 as much money as the investor who purchased them, held them over the years and sold them out. He made a substantial profit on them. They did almost as well. So what does that say to you? I'm going to talk about it in this little videos coming up here. They talk about rental properties. Anyway, Bijou, if you want to run that puppy, go for it. I put it together in a video as I usually do, so.
So today what I want to talk about is what's happening in the rental housing market. And also important is how to make an accurate and instant offer for a rental property. This is one of the biggest questions I get all the time. How do I know what offer to make on a rental property? So first of all, I'm not an attorney, CPA, or realtor, so any information derived from this presentation is not to be construed as legal or accounting advice. And for purposes of FTC, I always talk about there is no average of results, so anything related to averages is unreasonable as far as FTC guidelines prevail. So let's look at a quick market overview first of all. What I've been seeing for financing of large multifamily properties is the buyers are facing steadily increasing interest rates, in some cases 0.5% to 1% of what was promised just a month ago. Now, I can't say it's a trend, but it's also happening and even more dramatically in commercial office space rental buildings. The question becomes, are employees going to come back into the commercial office space, or are they going to simply stay working at home? Now, investors are always faced with having to place their money in opportunities where their money works for them, not they're working for the money. This should be a problem you have to face someday. Too much money and no place to put it. This rush to invest funds is a real issue and drives investments and interest rates. However, despite the immense increase in materials cost, it's still cheaper to build units and single-family homes than buy in most cases. Apartment buildings and single-family homes are popping up everywhere to meet the current housing needs, resulting in a constantly increasing need for funding. For this discussion, let's look at what types of rentals we'll be discussing. Single-family homes as rentals, as well as multifamily rental properties and any number of units. The concept of renting single-family homes is not new to real estate investing, but what is newer is the concept of building a portfolio of these homes with the sole intent of selling them out within the foreseeable real estate cycle. This is the most basic hedge fund strategy. In this methodology of getting the maximum return on the invested dollar, an appreciation rate is factored into the basic income model, which is usually never done in the case of multifamily properties. Whether he intends to rent a single-family home or not, an investor should look at what offer to make based on the value of the property as compared to other similar single-family homes in the immediate area. The investor's goal is to have the single-family home rental pay the mortgage and provide a cash flow until just the right time in the marketplace to take a maximum capital gain. This basic strategy works when the investor doesn't overpay for the property and later can't get his money out if the situation arises. Another example is where single-family homes have been purchased above market value with the intent to hyper-rent them as vacation rentals or Airbnb units. The concept has made many investors tons of money and has also caused untold losses of capital when the concept worked for a short time or it didn't work at all. Many of my students who started paying full market value are over for duplexes and triplexes years ago and went to Airbnb have since sold the properties because they've appreciated, and the Airbnb concept is intense in the terms of labor and cost and so on. For this example, we'll look at what a standard of pricing should be when used to purchase a multifamily property for 2 units to 200 plus units. When determining an offer price for a single-family home, an investor looks at comparable closed sales in a specific radius of the subject property and assumes that his property should sell at a similar price per square foot. If he has done his research carefully, he will easily be able to determine an offer for cash or creative financing. Unfortunately, this evaluation can be fraught with errors, especially if there's no comparable sales or the sales are not in a reasonable proximity of the property in question. His fallback is that when he rents it, he will have income to cover his mortgage unless he loses his tenant. In the rental market, a standard has been established that is simple and reasonable. This standard is called the cap rate or capitalization rate, which in the simplest of terms is the net income a property produces annually divided by the net cost of the property for the investor. Again, in the simplest of terms, if you put all the rental income in a bank account and from the same account pay all the expenses for the property, how much money is remaining in the account at the end of the year? This net amount of money divided by your purchase price and initial repair cost is your cap rate. For example, if the remaining balance in this fictitious bank account was $9,000 and you paid $100,000 for the property, you would have gotten a 9% return on your investment for the year. So let's start by looking at an example of a multifamily property offered by a seller and given the following information. 3 units each having 2 bedrooms and 1 bath, all units rented for $500, $600, and $600. Estimated repairs needed $5,000 per unit. Expenses are available to the buyer but won't be specifically listed here, as we'll see them shortly. Investors asking $250,000. Is that a good price? That's the kind of question I get on a regular basis. Specifically, let's look at what offer you should make and how you get that offer. To answer these questions, let's get a better understanding of both the traditional and what I call the fast and furious way to make an offer on multifamily properties. A red flag is when a seller says his rents are below market value and can be easily raised, and he uses the proposed rents to determine your anticipated cap rate. Warning: make sure you ask if all the units are rented and all the tenants are up to date with their rent. If you're serious about purchasing the property, I suggest you talk to the tenants individually, and whatever rent you have been told they're paying, add $100 as to what you understand they're paying and see what feedback you get. There's also the question of their rental and security deposits, which you may not be able to get from the seller. Each tenant has to sign an estoppel letter stating that they understand the property is being sold, their rent rate, deposits, and they're complying with the terms of their lease. It's important that you actually see the leases to determine you're not inheriting a sweetheart lease that you have to abide by that is financially unbearable for you. Sweetheart leases are well below market value and for extended periods of time. The question always arises, is it better to buy a property with no tenants in it? Are tenants already in it so it's a fully functional property? And that's in the mind of the buyer. If you're wholesaling the property, some buyers will not want any tenants in there. They want to screen their own tenants. Others want the cash flow instantly, and they will weed out the tenants as time goes on. And typically those guys are the ones who are in the business for a long time and accumulating property. They're not afraid of evicting tenants. So let's review the specific property that I mentioned. 3 units each having 2 bedrooms and 1 bathroom. This doesn't matter. There could be 6 units, each having 2 bedrooms and 1 bathroom in another state and getting the same amounts of rent that we saw or we're going to see in a second. So again, the only thing that matters, frankly, is the gross monthly rental income. In this case, the units are rented for $500, $600, and $600. So the gross monthly rental income in this case is $1,700. Do not multiply it times 12 and so on and so forth. Just look at the gross monthly rental income. Now I am going to put in a repair estimate of $5,000 a unit, and the reason is I updated the rental return calculator and you can see how that's working. So the investor who's selling it is asking $250,000. The question is that a good price? So what I'm going to defer to now is the rental return calculator. So what you see here is the rental return calculator. As you'll notice, it's split into 3 parts: calculating the cap rate, cash on cash rental yield, and finally calculating your net yield using a rent divisor factor, which is the fast and furious method to determine what price to offer. Now, for the sake of being able to see it, I'm going to enlarge each one of these and go over them in detail. So this is the first part of the rental return calculator. I mentioned to you before the rents in unit 1, 2, and 3, 5, 6, 600, total is $1,700 a month. Anything in yellow on the calculator you can fill in, and it doesn't matter if these are 100 units or 10 units. I just happen to have set it up like this to make it convenient. Now what I did do is I filled in $250,000 as the purchase price, and what I'm going to also do is fill in, if you remember, I mentioned the estimated repairs were $15,000. And as you'll notice down below, it automatically calculates the cap rate. Now how does it do that? On the right-hand side, it takes into account various general expenses: vacancy rate, insurance, management company. You may say to yourself, I don't need any management fee, and I'm not going to have a vacancy rate. And this is one of the ways that the seller can increase his cap rate. As you've seen what's happened, it's gone up somewhat quickly. Now, how about his taxes and so on? It doesn't matter for this observation. What I want you to know is if you in fact look at things like the vacancy rate of 6%, which is low on the industry standard, and you look at a 10% management fee, for example, you're looking at a cap rate for you as the buyer with the repairs that you estimate of 5.22%. Without those repairs, 5.53%. So the question becomes, are you happy with a 5.53 cap rate? I want to change one thing here just to show you how this works. Very oftentimes what I see is this type of property is offered for $300,000. There you go. Now it's 4.6% cap rate. And you can argue with me about, well, you ought to have all the exact expenses in. It doesn't matter. The expenses aren't going to make that much difference. But you can fill in the exact expenses. You can look up the taxes in the public record. Say the miscellaneous expenses are $1,000. Whatever you want to play with. Notice how it just dropped to 4.31 and 4.11%. And sometimes what I see is properties just like this offered for $350,000. Now we're getting into less than 4% amounts. But let's do this. Let's go back to the 250 so I can show you some other examples of cash on cash and other things that would be important to you normally. We said that this miscellaneous was $100 a year, but these are the same numbers we started out with. The rental return calculator carries these numbers forward into the rest of the spreadsheet. So this is a cash on cash rental yield. And if you said, Dave, my purchase price is $265,000, that's the 250 plus the 15,000 in repairs. And if you put down 10%, in other words, you got 90% financing on it, what would happen? Based on a 5% mortgage, you can change this mortgage. This is one of the new updates I made in it. Instead of putting 5%, I can put a 6% mortgage in there to see what happens. And I can also put in a 4% mortgage to see what happens. As you'll see, with the 10% down, you're actually going to have almost no return at all, or a negative return. And some people, especially in other countries who look at astronomical inflation rates, do not care about having literally a negative or break even because they know their dollar and the real estate market will be stable here rather than in their own country. But let's say you do a traditional financing here and you put in 20%. That's what you should expect. And your cash on cash return, meaning the 20% that you put down or $53,000, is going to be 3.2%. Now that cash on cash is for the $250,000 purchase. Cash on cash with the 265,000 repairs is 2.5%. So is 2.5% return on your cash on cash of $53,000 a good return? It depends. It's in the eyes of the beholder. But this will give you an idea. So let's look at putting up 90%. In fact, now you have about a 5% return on your money. So are you better off to put up less money and have more return? These are all numbers you can play with. My focus is on how do I make a fast cash offer on this particular property. So now we move into the third part of the spreadsheet. And what I devised years ago was how to make a quick understanding of the actual return or cap rate on a property just by looking at the gross monthly rental income. Why did I do that? Because at the time I did it, mortgages were 10%. And if you say to yourself, 10%, that's unbelievable. No, those were FHA mortgages, which after that went to 14%. Interest rates in the banks on CDs were 18%. And if you're saying to yourself, Dave, I'm trying to get 5 or 6%, why don't I just buy a CD? There may come a time when you can buy a CD again for 18%. And what will happen is the people who are holding rental properties and getting a 5% return on their money is fine unless they go to sell them. Then they're going to have to sell them at a cap rate that's equivalent to slightly better than the bank rate. And as an example, as I mentioned before, anything with a yellow background on it, you can change. I happen to have 3.25% in here. That's a divisor factor just like 1% is here. So let's set this up. $1,700 a month, gross monthly rental income. Doesn't matter how many units, doesn't matter whether they're 2 1s, 4 2s, 1 1s, or efficiencies. What's the gross monthly rental income? If you divide that by a factor of 1%, That would be 1,700 divided by 0.01. You get a purchase price, an offer price of $170,000. If you divide that same by 2%, you get an $85,000 purchase price offer. Now remember, the seller's asking $250,000. So you're saying to me, Dave, that's ridiculous. I called it the 2% rule when I made it up originally because initially when I did this, we were offering a 3% offer rate with a divisor of 3%, obviously. So we were buying these duplexes, triplexes, quadplexes with a divisor rate of, again, 3%. The most we ever got was 0.0325, or 3.25% rate. So we would pay, instead of $250,000, we were paying $52,000 or $55,000 or $60,000 for that same unit that you're looking at buying now, $250,000. If you're saying to yourself, was that the turn of this century or the last century? This was in 2008, 9, and 10. There was a scourge of REOs coming to the marketplace. And the one thing that lenders don't like is tenants, toilets, and more importantly, liabilities. And you could buy REOs with that divisor factor. But let's be realistic. What's the net rental estimated yield here? At a 1% divisor factor, it calculates it for you. Here it is, 8%. You want 8% on your money? That's where you need to be. But let's go and change from 3.25% to a divisor factor of 1.4. That means you can offer $121,000, get 11%. But Dave, you're going in the wrong direction. So what we have here is if you're shopping for a multifamily property and you want an 8% cap rate, then you're going to have to offer $170,000. That's the bottom line. But if you're willing to take something between $170,000 and $250,000, or a cap rate of somewhere between 8 and on the low side 5, you can then offer in between. Again, is $250,000 a good offer? It's a good offer in the eyes of the beholder of someone who's getting less than that on their money, wants to put it into something that's a rental property. But for you, let's say as a wholesaler, what you're going to have to do is use a divisor factor of 1% to get an offer price of $170,000, where you can then reoffer the property for that $250,000. So what you're going to do is reduce the cap rate. So for future reference, to make a fast and furious offer, when somebody comes to you and says, Dave, I want $250,000, here's what the income is, or $350,000 or $450,000 for the same property, divide the gross monthly rental income by 1%. That would be your offer price. Now it's going to be probably substantially below what they're asking. But let's say that it's not substantially below what they're asking, simply because of the area that the property's in. And an 8% cap rate is actually low. They could be saying to you, Dave, I want $85,000. So if a seller comes to you with an idea of here's what I want for it, here's what the income is, they give you all these stats, you can fill the stats in so you can get the actual expenses to get a more accurate cap rate. But while you're trying to calculate the cap rate by an extensive spreadsheet, another investor is going to come along and use this fast and furious method to just make an offer and get it under contract and then do those calculations after the fact. If you're buying a property that should be in an income area where it's between, let's say, 3 and 6 or 7%, or they're large apartment type complexes where 4% or 5% in these days and times can be a good rate, then you use a factor of 1%. If you're in an area where rents are higher because they're harder to collect, you have more vacancies, you can use the 2% divisor to figure out an offer price. Or in between the two of them, use the calculator and just simply offer 1.5%. As you can see, it's somewhere in between. So here's my point. If you buy at a divisor factor of 1.5% and you sell at a divisor factor of 1%, it's in reverse. The lower the divisor, the higher the price. You have purchased something at approximately $115,000. You're looking to sell it for $170,000. That's wholesaling multifamily properties. Typically, that wholesale spread should equal at least 2 to 2.5 or even 3 years of net income to your end buyer. So I wish you limitless success in all you do. I hope this helps you in making your next multifamily offer by knowing just one thing: gross monthly rental income.
Jim, I wanted to mention that we've kind of had a real uptick in students who have been in the system for a while and have not gotten anything are starting to get things now. And I think it bodes well for persistence. If you're doing what you're doing consistently and persistently, it has to work out for you. You hear all the stories about everything goes well over list price and there are no deals and so on, and that's not true. Everything that goes well over list price is because it's rehabbed and people are paying very little as a monthly payment because of low mortgage rates. Those are not the properties we look at. I see plenty of properties from students all around the state that frankly, they say to me, it's listed at 225, they're willing to take 200, my offer was 180. Should I counter? I look at the property and it's magnificent. It's been rehabbed and it's not selling. One of the reasons we use at least 31 days or more on the market is because if it's going to go quickly, or if it's going to go quickly, and it's going to be within 5 days. So there's a lot of opportunities. You just have to keep doing it and going back on it. You've heard me say this a million times, money's in the follow-up, and that's true. Let me ask Jim something real quick.
Can I
Jim,
cut in about that real quick? We had a student that's been working on one deal for the last, I think, 6 months.
Oh,
Right? It had a lot of problems, and we had sold it then, but it took so long. The buyer went away. We kept on it. He every month we got an extension. The seller finally fixed all the problems last week, and on top of that, he gave him 2 other properties. So we had he got 3 properties altogether, and we sold all 3, I think, within 2 days.
you know who that is, Viju? I mean, Dave, you know who that is?
no, I
Nick.
can't say his name, but
I
Yeah,
can say his front name.
well,
And
go
so,
ahead.
and so, yeah, his first name is Nick, and it was Viju. Viju kept telling him, "Don't give up," and he's right. Every month they did an extension, every month, and then the guy gave him 2 other properties. So that it goes to prove your point, Dave.
Let me ask Jim something I've been trying to get to ask him. If an investor comes into you, Jim, and he says, I got it under contract, you run title on it, and you find out it has these liens, code violations and stuff. Is your stance that the investor needs to go and negotiate those, or do you negotiate those for him?
So we typically put that on the seller. It's not something that if it wasn't disclosed, the contract typically the sales contracts, especially properly prepared, should call for the seller to close any open violations, code violations. So we typically put that on the sellers. From my
Okay.
experience over the years dealing with code liens and code violations, and I have negotiated some and I have not negotiated some, and as well as I've had the other parties negotiate them. The best results are always the homeowner. The cities aren't necessarily going to negotiate with you before the issues are fixed. So when a seller comes to them and says, "Listen, I have no money to fix this place," or "I only have a little bit of money to fix the place, I can't also pay the lien. You need to come work with me in regards to getting the work done to fix it," which is going to cost money. Typically if it's a roof or it's doors and windows or something, it's going to cost money to fix. And that money needs to go towards the community enhancement by fixing the property compared to negotiating it. The seller or the current owner typically has much more wiggle room. Once the closing happens, my job is typically done. If the sale happens and then the buyer is going to negotiate those liens, there's going to be a 6 month or a 3 month to 6 month gap period between them owning it and getting those liens negotiated by getting into compliance and taking that long. So it's not something that I typically deal with negotiating
Yeah.
before
Okay.
if they're out of compliance.
Okay, so for the guys who are listening that may come into this, I have a different approach. And that is I sashay on down to the code enforcement, which is where you're going to find out what the liens are and stuff. And I say to them, or I send Nancy in to say to them, "We're going to buy this house. We're very concerned. Can you help us?" They always use the word, "Can you help?" because that's like a push point. So we had one of these where the person that was selling a house had not mowed the grass, $50 a day fine for 9 years. It was 260 some thousand dollars for unmowed grass. Obviously, in the 9 years he had mowed the grass, but no one ever came back to the city, or it was a county in Broward County. So when we went down there and I said to them, I need some help with it, the guy was very nice and he said, well, we can take that down for you. And I said, great. What does that look like? And he said, we'll charge you $256. And I thought, okay, instead of saying, are you sure? Did I hear you right? It's like, okay, all I could have done was heard it wrong. But I went from $256,000 to $256 because I asked. And sometimes your sellers are uncooperative. They don't mind the junk cars in their yard and they're not paying anything. You're running up $300 a day. I had,
Junk, it's a collector's item.
the city doesn't care about that stuff. What they care about is, get rid of it or else. And the seller says, I'm not doing anything. They start fining you.
Dave, if it's property maintenance, that's a different story. It's an easy fix. You can come in there and clean it up yourself. And then the city, once you clean it up, then the city's going to talk to you. If you don't clean it up and then try to talk to the city, they're going to have a different conversation with you. They're always going to have a much different conversation with you if you haven't gotten into compliance. And they have neighbors bothering them. They have people driving on the street saying, why is this lawnmower in the middle of the lawn with the grass super high? But if you can get it into compliance and talk to them about reasonability of, the amount of the lien compared to what they're going to get for the property, it is something you can get major deals on, because you can get negotiated prices on, where a seller is just going to say, I'm going to sell it to the highest bidder, but then those bidders are maybe not going to work to try to make it happen.
So what I also see a lot is some cities will say, fix it first and then we'll negotiate. Well, that's an open trap, because what if it's $200,000, you fix it and they say, all right, we'll only take 180. Your deal's done and so are you. Normally what happens is those are going to be sold to contractors who work the area, like Miami Gardens. Those guys that work that area, and they know every code enforcement person and so on and so forth, and they know exactly what that's going to take to fix it. So what we do is sign a hold harmless at closing. I say we. The end buyer signs that hold harmless, and it designates every single thing that you find in the public record. That's a problem that they're going to accept. And that's not uncommon. It's a regular occurrence and it can be done. So if you say to yourself, well, look at all these problems, and the seller's not wanting to cooperate, I can't fix them because the city says this, it doesn't mean you can't sell it. It only means you have to fully disclose it and have the end buyer take it, and make sure you do that before he signs your contract on it, so he doesn't walk away from it. At any rate, any other last comments, Jim?
No, I think we've got it going here. I want to tell people that we will be sending your video to all the attendees along with the video of tonight. Thanks for joining us tonight. We hope to see you again at another DREIA meeting. If you want more information about DREIA's Change Your Life Mentoring, please visit us at DREIA.com.